Hi there, it's Joe from Striped Unicorn. Welcome back to another session on sectional title schemes. In today's session we will be chatting about the management agents and their responsibilities. Let's get started with the definition of a managing agent. According to the Sectional Title Scheme Management Act of 2016, a managing agent means any person who provides scheme management services to a body corporate for reward, whether monetary or otherwise, including any person who is employed to render such services. So how is a managing agent appointed? In the Prescribed Management Rules, number 28, of the Sectional Title Scheme Management Act, 8 of 2011, deals with the appointment of a managing agent. The trustees may appoint a managing agent, and must do so if instructed by the majority of the members of the body corporate. There is nothing in the Sectional Title Act that state that the trustees must consult the owners before making a decision to appoint a managing agent. But the owners can place such a restriction on the trustees at a general meeting. The owners can, by ordinary resolution, also require the appointment of a managing agent. The trustees must ensure that there is a signed management agreement with the managing agent. Initially, the appointment was for 1 year, and thereafter, it was automatically renewed on a year-to-year basis, unless the body corporate terminates the contract. On the 7th of October 2016, this changed to, a management agreement may not endure for a period longer than 3 years. This doesn't mean that the body corporate has to get a new managing agent every 3 years. It only means that, a new management agreement must be signed every 3 years. Some things to consider when appointing a managing agent. A managing agent must be registered at the Property Practitioners Regulatory Authority, also known as the PPRA. Must have a valid Fidelity Fund certificate. Managing agents are also recommended to have their own fidelity guarantee in place. They must be registered with the Council for Debt Collectors in order to collect levies on behalf of the body corporate. The managing agent, or an employee of the managing agent, that renders services to the body corporate, cannot be part of the trustees for the body corporate. It is important to take the following into consideration before making the final decision. The body corporate's money is protected when using managing agents that is registered with the PPRA and with a valid Fidelity Fund certificate. Unregistered managing agents and invalid Fidelity Fund certificates leads to unprotected money of the body corporate. And with a self-managed scheme, the money is unprotected, and anyone can misappropriate funds. Reliable managing agents do not just rely on the PPRA Fidelity Fund cover, but also take out their own professional indemnity cover. When you are looking at different managing agents, make sure you clearly understand what they are offering for the fee the body corporate will be paying. The lowest fee does not mean they are offering the most comprehensive services. Ask them to list their services so you can compare to other proposals. Ask about their infrastructure, how many agents they have, what happens when the agent assigned to the body corporate goes on leave. Make sure you don't end up with someone that does not have the capacity to render the service they are offering. Let's look at how to end a management contract. The Sectional Title Scheme Management Act now states that despite any provision in the management agreement, to the contrary, the body corporate may give 2 months' notice after passing a special resolution to the effect. The Act also states that the body corporate or trustees may cancel the management agreement when it has expired, in accordance with its terms by passing an ordinary resolution. And in the same token refuse to renew a management agreement. Since the 7th of October 2016, when a body corporate has decided to terminate the services of a managing agent, the Sectional Title Scheme Management Act includes the provision that such a managing agent will have 10 days to hand over all records of the body corporate. Let's look at types of services that can be rendered by a managing agent. Clearances. In terms of owners selling their units, issue clearance figures, a clearance certificate, and allocate the monies received. Open a levy account in the name of the new owner, and sending a welcome letter with the rules. Keep records of employee-related issues like contracts, payments, and leave taken. Open and operate a trust account for the body corporate. Get mandates and open investment accounts for the body corporate, including a separate account for the reserve fund. Transfer monies between the accounts as needed. Assist the trustees with the insurance replacement valuations. This need to be done every 3 years. Assist the trustees with insurance policies and insurance claims. Assist the trustees with getting rules approved. Correspondence regarding contraventions of the acts or rules. Give advice to the trustees and owners regarding the sectional title legislation and interpreting of rules. Keep records and assist the trustees with things that needs annual services, like getting the fire equipment serviced. Assist the trustees in getting quotations for work that needs to be done on the common property. Keep copies of any contracts the body corporate may have with service providers. Get the trustees to sign the necessary resolutions, one for levies, handover, and interest resolution. Ensure that levies are correctly raised. In-house debt collectors to collect the levies, up to the stage when it is decided to hand the owner over to attorneys to collect the levies. Allocate payments to the owner's levy accounts. Provide the owners with levy accounts, and reconciliations of their accounts when needed. When there are sufficient funds, and with the necessary authorization, pay the following: recurring invoices, like garden services, ad hoc invoices, municipal accounts. Record keeping for the body corporate. Keep a database of owners, trustees, and tenant contact details. Records of all correspondence with owners and trustees. A copy of all statutory documents of the body corporate, like the sectional plans, the rules, and more. Minute books of all meetings held. Assign trustees a login and password to their complex's property portal on the online systems, in order to view financial reports. Advise the trustees and owners on the procedural matters regarding meetings. Arrange meetings, on instruction from the trustees. Attend the meetings, normally trustee meetings, and the AGM, and in some cases SGMs. Attend to the minutes of the meetings where needed. Draft a proposed budget for consideration and approval by the trustees, before tabling it to the owners for approval. Give the trustees monthly financial reports on income and expenses, and variances between the budget and actual income and expenses. Assist the trustees with the annual audit of the body corporate. If appointed as public officer, assist the trustees with all tax matters pertaining to the body corporate. Raise and collect the CISO's levies and pay it over to CISOs. Assist the trustees with getting rules approved by CISOs. Do the annual return to CISOs on behalf of the trustees, if so instructed. Assist the trustees with matters going to CISOs for conciliation or adjudication, normally extra costs involved. This brings us to the Executive Managing Agent. With the new Sectional Title Scheme Management Act that came into effect on the 7th of October 2016, a new concept and role was introduced in the sectional title industry. Like the managing agent, the Executive Managing Agent is not even mentioned in the Sectional Title Scheme Management Act. They only gets mentioned in the prescribed management rules. The Sectional Title Scheme Management Act, Prescribed Management Rule 2G states the definition as Executive Managing Agent is a managing agent appointed to carry out all the functions and powers of the trustees, in terms of Rule 28. It is now possible for the body corporate to appoint an executive managing agent by passing a special resolution. If it is not possible to get the special resolution passed, then members entitled to at least 25% of the total quotas of all sections may apply to CISOs for the appointment of an executive managing agent. The executive managing agent will take over the functions and powers of the trustees. So there will not be any trustees for the body corporate. Appointing an executive managing agent will be a good solution to complexes where nobody wants to be a trustee, and it is less invasive than having an administrator. This brings us to the administrator. The function of the administrator is to take over the functions and powers of the body corporate and the trustees as a whole. Having an administrator can have a detrimental effect on the reputation of the body corporate. This is, however, not always the case. Before we go, in the next session we will be chatting about the first meeting of new trustees and what happens at that meeting. Thank you for staying to the very end of this video. To never miss out on our content, click on the subscribe button and set the notification bell. You can also show your appreciation by liking our video. If you have any questions, please chat to us down in the comments. We are looking forward to chatting to you soon.